need to be clear in statute what we're expecting for staffing. But you said earlier.
Yeah. So I relayed the preliminary assessment, which was 2 more attorneys, obviously the 2 more full-time board members, and then possibly like a clerk position, keep the wheels moving administratively.
So it was just 3.
Well, that would be
keep missing
5 total.
And that's for the straight
Oh,
enhanced.
right. Well, 3 board members.
Right, but one of those already exists.
Yep.
So yeah,
Sorry.
so it's just it would be 2 new full-time board members, 2 attorneys, and possibly a clerk position. And I have relayed to the board's business manager, Kimberly Lauschua, that it would be very helpful to this committee to have some dollar figure estimates to make that more concrete. And she has represented she is working on that. So
I see there's questions. I just want to be clear. The joint proposal had hearing officers in there. And I would like someone from, like Matt, to speak to that.
So, for the record, Matt Chapman, General Counsel for Meenan. Yes, there are hearing officers in the joint proposal. I think the concept that Evan put out there is consistent with that. I mean, you could either have a single commissioner acting as a hearing officer. You could have a district commissioner acting as a hearing officer. Or you could have a board counsel, which is typically how it happens, acting as a hearing officer on a given case. So you wouldn't necessarily have a person whose sort of sole job is a sort of hearing officer title. It would be sort of a duty, a set of duties assigned to an employee.
Right, and I assume maybe it could a district coordinator from another district who wasn't busy also be a hearing officer in another district?
Yes, they could.
Okay. Okay. So, I don't know where we are. Carol.
I was hoping we could have some money in the budget for there to be the hiring of experts or the hiring of mediators or facilitators, or do we not do that?
We've talked about it. We've talked about
What do you think?
we've talked about kind of the challenge. It gets kind of to multiple things around paying A&R staff to assist with decisions, getting expert witnesses for district commissions we've talked about. In this case, it would be for the enhanced board, most likely, because they'd
Right.
be doing the majors.
I don't mean a full-time position, I mean some money in the budget
Yeah.
that they can use to hire somebody if they need to.
Well, there's been a proposal to increase fees to do that. Jim?
I'm torn with I have been torn by do less, accomplish more, go slow to be fast, keep the status quo. I think there are people in this room who want to do that, but I understand there are that brings its own baggage, and that I think hybrid 2, while it brings its own baggage, permits us to move this guy along. It does have 2 full voting district commissioners. I think I'd prefer 3, so that 3 on 3 is always a better outcome for the whole project than a power play, if you're thinking hockey. I think this may be the spot, and Ellen, you'll have to help me and help the committee, but this may be also the spot where we do some direction around this board. Currently, Evan, we have 2 attorneys. We're thinking of adding 1 attorney to this hybrid 2. I'm thinking adding 2 attorneys.
that's what we were thinking as well too.
Yeah, it's got 2, I think.
Oh, you did. And I'd like to, I guess this is for Evan, I'd like to have enough attorneys there so that one of them can split off and give advice, legal advice and help to the various district commissions as they need it. And in the case of appeal, recuse themselves. So does a total of 4 attorneys get this done, or we need 5?
We were estimating 4. We thought we would handle it the same way you just described.
Mm-hmm.
And our estimate was that we could probably get the job done with 4.
Okay.
That's what we were hoping. I mean, if we're wrong, I guess we'll come back and
And ask for another one.
We'll let you know.
Yeah, yeah,
But
yeah.
we thought it was a good start.
Yeah. And yes, and so yes to everything else everybody else said. I don't know if this room wants to discuss 3 full-time voting district commissioners to level that playing field completely, or not. If somebody else speaks, then I'll know we're moving in that direction a little. The question was raised by the chair, Diane Snelling's chair, that, well, Jim, what about a tie? And
Tie fails.
well, it's been put to me that, well, maybe the rule making will decide, does the tie fail? Does the tie send it back to themselves for just those 2 or 1 or 2 issues? I don't know, but that could be done with rulemaking. What happens in a tie? But I support hybrid too, and with as it's presented by Trevor and Carrie, but I would like to see a 3rd voting district member there. So 3 on 3.
Paul?
Yes, I agree with you, Jim. I would like to see the local representation equal to the professional group of 3. I'd like to see it 3 on 3 as well, because I'd like to know or have some assurances that these decisions are somehow going to be place-based in terms of what's coming out of the various districts. And I do, if we're talking about regional economic development, and I think we do have, there is vast differences among the regions, and I think somehow to have that represented on a decision would get some weight if you had a board in which, or a commission in which there were 3 people from the local or the regional area where the project is slated, as well as this board of trained professionals. And I'm very reluctant just to go along with that entirely, because I don't really like the PCU model. I'm afraid it won't do justice to the local regions, and I'm also afraid of the access maybe curtailed, or it wouldn't just be as people would not be wouldn't be able to kind of feel that kind of sense that they're all one of us. I hate the idea of someone else making a decision for us in terms of the neighborhoods in which we live. So if we're not going to allow what already exists to continue with some training as suggested by testimoniicity, then I'll go along with a 3 by 3. But that's, to me, that's I do it dragging my feet, but I'll do it.
Matt?
I'll agree with everything, although the 3 on 3 thing is an interesting idea. But it does, I don't know if I would enjoy leaving it completely up to rulemaking at this point. I think if that's the route we do go, I would prefer to, for us to give them some guidance about how to go about the rulemaking and where the legislature thinks, what happens in a tie situation. I think leaving it up to leaving it up to rulemaking, I think for most of the time works out just fine, and it's not an issue. But
Yeah.
In a situation as large as this, and 250, and Act 250 stuff, I think it would probably be better if we gave them some guidance along what happens with a 3 tie.
Yeah, you know, excuse me.
What's up, folks?
That would be my preference. Also, one option was tie vote fails.
Right.
I'm gonna say that if the project is bad enough to end up in a tie, one other option would be go back to the table, boys, and get it figured out. And by boys, I mean kids, everybody, males, females, and so on. Because if it's that bad,
Something's up.
something's needs fixing. And so that could be a solution too. And it goes back to their own table, and only for those issues
Right.
that they were tied on.
Sure, Paul.
And I don't think we should presuppose that the split's gonna be between the 3 regional guys and the 3 trained individuals. I think, who knows how it will break out, but I think Jim is right. You keep it within that group and they'll go back and work it out. If there is a tie, then somehow you've gotta be able to resolve what's the problem here. And I'd rather leave it in the hands of the 6 people who have heard this testimony to go forward than to, cut the number down to 5, 3, 3, and 2. There's never another bite at the apple, so to speak.
Lee and Carrie.
Joint proposal for me, enhanced board, that's what I most
Can you support the hybrid too?
would be my second choice, and I can understand. I could, yes, but I prefer the enhanced.
And what about the membership, what we're talking about?
The 3, I don't know, I just wanna hear more.
I appreciate the conversation, and I think part of it is, from my perspective, is probably embedded with a new system and and our concern about local voice. In my opinion, and I respect and appreciate other opinions on this. In my opinion, the preservation of the district commissions and their role is, I think, fundamental for helping to continue the role of that local voice in making the 2 regional commissioners with full voting rights as part of the full-time board. I personally would have confidence in that. I've sat on select boards and other boards, and it's an efficient way to have an uneven number. And it's not to say that decisions are always on a close vote. Every commission I've sat on has always tried to strive for consensus. But I do, if we were given more resources to be thinking about that, I would rather dedicate those additional full-time equivalents to meeting where I see there are gaps in the system, and that is providing legal support, technical assistance and training to ensure that we're providing the right, we're being able to stand up this enhanced board with the right type of support. So I actually support the hybrid too, and maintaining it with 5 full-time board members and the staff that was described by Evan.
You mean full voting members, not full-time?
Full voting members, yes.
I'm at 3.
Having the 3, there's, the
3
3
full-time.
full-time plus the 2 regional with full voting.
So 5.
5, and then we described and heard from Mr. Chapman about the likely, what we call full-time equivalent FTEs to support this proposal, which would make sure that we have the lawyers and the administrative support to provide that legal support and educational and training support.
Carol, are you?
I'm okay, but I have no problem with 3 and 3. And we can,
Do you have a preference? I mean, we're,
I like hybrid too,
with
I
five
do like
members.
hybrid.
5 members.
I think I'm hearing some support for hybrid 2. Paul reluctantly preferring strongly if it's hybrid 2, there's 3 and 3. Our the good news, team, is that we're moving in on our range is not that far right now.
What about the verb?
Just kidding. I love you.
I have a question.
Yeah.
If there's, right now, I understand it, that if a district coordinator releases a jurisdictional opinion, and that's appealed, and the first step is then the district coordinator reviews that opinion. In the event that he doesn't change his opinion, or her, then it goes to the E-Court. And I'm wondering now what will happen if we're now going directly to the Supreme Court.
I think, I'm pretty sure it would go to the Enhanced Natural Resource Board for a reconsideration.
So we'll go back to the 5 members.
That's a question mark. The 3 members or the 5 members. If it's in a region, I'll let Matt answer that question.
So for the record, Matt Chapman, General Counsel, NR, I mean, Evan and I were talking about this earlier. I mean, I think if, depending on how the legislature constructs the duties of these district commissioners and what their role is, you probably wouldn't want them setting in review of a JO that they had oversight of at the district level. So I think at least.
So I think we moved away from that idea. It would stay that the district coordinator
Okay.
was still responsible for
For the
JOs,
JOs.
like they are now.
Okay.
So through that lens.
Who should hear the reconsiderations? Is that the question?
So,
Yes.
well, the reconsideration of a JO, we agree, would happen at the Enhanced Natural Resource Board level.
Who should sit on the board?
Who sits on that board?
Oh.
It seems,
Should it be a smaller panel for purposes of JOs and have the 3 permanent members, or should it be the whole 6-member panel or 5-member
and
panel?
this is not a question we need to answer right now, but.
We're happy to think about it and have a conversation and bring
Yeah.
something back to the
And we
committee.
can all do the same, but it's a good question. So, let's stick to, are we ready to, Trevor put a motion on the table. After this discussion, do you still feel the same?
Yeah, I support my position.
You like 5 members.
And I second that.
So his motion is, I guess, been made and seconded by Carrie that we go with the, what we're now calling hybrid 2.
Assuming I
made
got
a
voted
friendly
all on the
amendment
3-3.
there.
I guess you could make another motion. But
Vote on this one.
Well, that's really a friendly amendment to the motion, and he had a second with
Of the
Paul,
amendment.
so we could vote on the friendly amendment, which
Yeah.
is to make it 3,
6.
and then we can go on preliminary.
Yeah, that's true.
That's what I would do.
Very good.
well,
I'm not so sure my right
wasn't a motion.
buddy looks at this as a totally friendly amendment. Another procedural thing would be for those, a suggestion for procedure might be vote for it with 2, and if you want 3, vote it down, and then there'll be a new motion for 3. But that's just a way to deal with it, an alternate way to deal with it, I don't know.
But we've already
I
made
think
the
Carol's
motion
more
and seconded it, so we have to
straightforward.
do, we have to,
I would do it my way, and here's why. Because if the 3 that you made as a friendly amendment, he seconded it by saying, I like that too. If that fails, then it's done. Then we go to the regular underlying motion, which is the NRB and, the
Hybrid 2.
hybrid 2.
Yeah.
And then it's all easy.
Yeah.
That is really what
And
I
we go-
think.
Well, you're an
I'm gonna
attorney
be very
and
firm
I
about
think-
that.
I
No,
think-
it's a Robert's Rules thing. Okay.
We don't know about Robert's rules.
Well, it's Masons that we go by, but it's close enough. So we should have discussion on their idea of 3 and 3.
Yeah, right.
Any more discussion on that?
Thinking of what I thought. Well, it's hard to
What do you
facilitate, think about what you think
Yeah,
at the
I
same
know.
time.
So what do you
It's
think?
just my situation at the time. Ooh, I'm torn. I think there's a lot of merit to having the district members have equal ratio on this new board, and I'm not sure I've been part of standing up a board that had 6 members on it, like ever. So, I don't know what that means.
Or we can,
I don't think that we should assume, like Paul said, that it would be always a 3-2 either, or a 3, I don't think that it's, that would sort of mean that we didn't have faith in the board we're setting up. On the other hand, we've also all expressed a very strong commitment to district commissions. So, I'm not much help.
you're not.
See both sides.
I'm totally for district commissions. I don't think it's a necessity in this decision.
I'm not hearing, I beg your pardon.
I said I'm not totally for keeping district commissions. I'm more leaning toward the joint proposal. But,
So,
Matt?
just to be clear, the vote is on the 3-3.
Yes.
Okay. At this point in time, the 3-3, I think, it just has, too many questions pop into my head, and it's hard for me to sort out. So I think I'll be more satisfied with a 5-member, with 3-2. I'm more comfortable with that. 3-3 is interesting, and I love the drama that it can possibly provide. I've had a great time this week.
Yeah, I was gonna say, we got a lot of drama this week too. You like that?
But I think at this point, I would rather have the 3-2. I think it's safer, less to sort out at the moment, and is the more measured path at this point.
Okay, and we're still voting on a draft of our bill.
Right.
So, let's call the question on 6-member board. We'll just raise our hands. Or you guys?
Yeah.
Yep.
All right, all those in favor of the 6-member proposal? 2. All those opposed? All right, so now we move on to supporting the hybrid 2 as we've discussed fairly extensively. All those in favor of having Ellen draft us a hybrid 2? Enhanced Natural Resources Board. Raise your hand if you're in favor. 1, 2, 3, 4, 5, 6, 7. All those opposed? 1 and 1 abstention?
yes.
Okay. So there we are. We will try on the hybrid 2.
I'm the bad boy.
Do it.
I'm the bad boy. How can this guy abstain and Lee can't?
You really can't abstain,
That
you
was,
really
I was
can't abstain,
absent.
but I mean.
So it's only a straw poll, I'm not a recorded vote.
Okay.
I thought the same thing, really. He's the vice chairman, I'm not.
I can't even remember what that was about. For what would
It
you
had to
just
do
said?
with cannabis.
You didn't want to vote.
And I didn't want to vote, right. I ended up being absent.
I throw this in
Why
for
couldn't you
levity as
abstain?
much as anything.
Let me explain. Typically, the rules on the floor are basically the same rules that apply in committee, except the situation we had on the cannabis vote. You cannot abstain in committee.
Well, so he can't either.
Well, that's a straw poll.
Straw poll
I don't
vote.
think we're gonna, if we were
No.
voting a bill out, it'd be a different story.
And we were voting language out with Lee's, but it was advisory, wasn't a bill. All right,
I would have to.
we're doing our best here.
But anyway, since you can't abstain, if you want to abstain, you need to be absent. And you can do that at any time before the vote is actually taken.
Yeah.
Okay?
Okay.
I raised this
All right.
just to poke him a little bit.
Hey.
I apologize for eating up committee time.
All right, so,
This is a straw vote, though, is it not?
Yes.
It's not binding.
yeah, it's not binding, it's to move us forward and
Well,
get a draft up.
okay.
Okay. Of course, we treated it pretty formally, but here it is. That's all right, it kept us organized
Good.
to the extent that we were organized.
Kept us organized.
Let's go. Let us go to the bill. So I'm gonna ask the committee's indulgence to go back a little bit on the revisions to the capability and development plan, having learned a little bit more about what this section is doing. Page 3 of draft 10.4. Yesterday we approved a new finding, and then I've since kind of learned that we would be updating session law from 1973. And I think what I would ask is that we consider having this be findings for our bill. Is that information that our ledge counsel agrees with what I just said? So like, I don't know if it seems, what I've understood from other attorneys in conversation about the bill is that this is going back and amending session law. And does that even make sense? What does that do?
Ellen Czajkowski, Office of Legislative Counsel. So, yep, it says right there, Act Unresolved 85 of 1973, and as we've talked about, these 19 existing legislative findings are what are being sort of referred to as the Capability and Development Plan, and are the goals. The Commission's report, the Act 250 Commission's report references that they are the goals that Act 250 as a tool is being used as a tool to achieve. So the Act 250 Commission process was looking for a way to tangibly insert climate change into those goals. So whether or not that makes sense to you is a policy choice, but yes, it's amending existing session law.
Well, I don't really understand, like, does it make sense to amend session law? Like, I don't. What does that do for if people wanna understand the goals of Act 250, is this the right way to do that?
It is one of the ways that you can do it. If it's the best way to do it is a policy choice, and it was a policy choice that the Commission made. Now, you having confusion around it may suggest that you do it differently, but that was what the Commission decided to recommend. So if it makes more sense that this would become part of the findings of your bill, it would again be session law. You could choose to do something else entirely, have it be directly incorporated into the statute as part of either section 6000 or a new section.
Jim?
We need an action step here so I'm going to propose that we do put these into statute. And the vehicle for doing that. How to do that is beyond me. I think you said enter it into section 6000. And how that would be written, I don't know, but I think these are all very, very important, and to have them in I guess they're in session law now, and I've only been here 18 years, and I still don't have a complete understanding of session law, and even quite how to find something relevant. and that may be totally on my shoulders. But I think that if it's in the green books, it's a lot easier to find. And for that reason, as well as for the policy, I believe this should be the policy that helps govern Act 250.
Gary?
I agree, I think that makes great sense. I'm nervous about affecting session law. It gets mixed up in sometimes legislative intent, and we're always going to be evolving into the future. So I like your suggestion of putting it right into a section 6,000 to reflect this language. It gets cleaner.
Ellen, correct me if I'm wrong, but I think the session law is legislative intent generally, right?
It can be. Having findings in session law can still be used as legislative intent.
Right. What else is it used for? You said it can still be.
I just meant that even though you can't necessarily see it right away, it is still used as legislative intent. It is also sometimes used for the justification on the floor, or when a bill is enacted as part of the enactment. So, yeah.
How do we find it? I'm just looking, I'm under Acts and Resolve, but first session comes up 2019, 2020. How do you find 1973 session law? Online?
No.
It's not online.
No, I've tried.
Yeah.
Okay, all right.
Well, so I have it on the screen.
Yeah.
So,
And for practitioners of Act 250, there's a book that has all of this in it, right? And I think I have that on my shelf at home.
so, yeah.
Yeah, Matt?
So it's my understanding that just because it's in the white books instead of the green books, it still has the full weight of the law, no matter, and the session law is more for findings and implementation dates and things like that don't necessarily be in the thing. But my real question, I guess, is is the thought to move all of the findings? I mean, this one we're adding here, and there is number 20. So we're adding all 20 into the green books. I mean, I don't
think we're prepared to do that right now.
Yeah.
I think that's a bigger question.
I don't. I personally don't see the need to add the findings. I think the people who even know what findings are, already know where to find. There's a lot of fines in this sense, but they know where they are. For cleanliness' sake, I don't know if we need it in the green book, but that's not a hard position on mine. I think you can convince otherwise. It's just I think traditional-wise, findings don't go in the green book, but don't go in the. Then they don't go. Then they don't make it in the green book. They don't make it online. I suppose. So I guess, yeah.
And Carrie, what did you say?
I commented about putting it under purpose.
Yep. And I actually have a thing about, it says clarify, 'cause the capability and development plan, page 5. Testimony this morning on this from Evan, who's luckily still in the room. So Evan, you told us how the capability and development plan, essentially doesn't exist.
It's not used really currently, but over the lunch break, I did go and track down the copy of what myself and Greg Boble and some other people that I've talked to think is the last version of the capability and development plan, and I did send that directly to you, Representative Sheldon, and to Ellen Czajkowski. I can send it to anybody else who wants it. But it's the interim capability and development plan that was adopted in 1972. I've got a copy of it and all of the capability and development maps that were part of it. And since 1972, I'm not sure much has really ever happened to it. And my understanding is that it is different from those legislative findings. You can see the preamble under Section 7, Legislative Findings A. It talks about how the findings are supposed to be used as the basis for the Vermont Land Use Plan, which is different than the Capability and Development Plan. And as I mentioned, I think earlier, there was supposed to be this statewide land use plan, and that sort of fell by the wayside as well.
Can I just respond to that? So Section 6 though, subsection A, this act constitutes the capability and development plan provided for in Section 6042. So this is the 19 findings we're talking about. So
I like it when I can read it.
sorry.
Can you just, I just wanna, oh, it's cut off here. Oop.
I wish someone was from 1973 was here who could shed some light on
What they were doing, yeah.
what they were thinking.
There probably is someone here. Perhaps not in this room, but probably not. Thank you.
I'd love to see it.
Yeah, I can send it.
If you send it to our,
I can't
to
find it.
Mark.
Did you send it to my legislature?
Yeah, I'll send it to Mark.
If you send it to me, I'll post it to the site and forward it to the committee. Thank you.
I'm looking. Yeah, I don't, all right. Okay, I need a little help here, team. What are people thinking? CO2 brand.
So what would you say, just say what you think the options are and we can choose one.
Well, I guess we're still talking about whether or not our addition to 1973 findings should amend 1973 findings or be a finding for our bill or go into the purpose section of our bill. I think that's what we're debating right now.
So the only question I have then, if it goes into the purpose section of our bill, does that negate its existence in this other place?
Not unless you repeal it.
Nope.
Okay, well then,
It's just
I
clear
think
for-
that it might be nice to have it in the purpose section of our bill, so it's right there for everyone to see, and then people can always go back to this also. But, you know, if you think having it in two places is too many, then I'm okay with not doing it.
Jim?
Having it in the purpose section, the session law.
And that's our
Having it
section law.
in the body of the bill, so we tell people what it is what I prefer.
Okay then.
If it's in the purpose section, it'll be as impossible to find as this was.
All right.
I think, that's where I'm standing on, and
Well, wait, if it's in the
Oh,
purpose section,
but
it's
that's our
chapter
bill.
151, section 6000, front and center.
Right. I think
That
purpose
goes
is
right
in.
into
Right.
state statute.
So you could be talking, and there's sort of two different things. You can either add a session law purpose section to your bill, or you can add a purpose section to the Act 250 statute.
That's what
I think
Okay,
that would be,
so
that's what
that-
I want. A
that-
purpose
that
section to
works
the
for
Act
me.
250
Yeah.
So
statute.
it's here,
That's all.
purpose.
Right.
And I have a note, clarify. And
Alright.
so this may be actually clarifying our purpose, but I wondered, I mean, these were added, when looking at the list of other 19. So This is so basic.
So-
We're doing this.
Right, so in your bill on page 5, section 6000 adds a direct reference to these 19, now 20 findings. It doesn't add the full text, it adds the reference to the goals of the capability and development plan so that there is a direct link without having the full text. So, again, that's a stylistic choice. If you want to add the full text of all 20 there, you can do that.
Let's do that. Let's do that, and then it's right there.
Well, we need to
Oh,
look at
we
it
just
before we
added.
just do that.
To how many pages?
Matt,
So, so we had extensive discussions about this when we were working on the joint proposal and found ourselves sort of in the same pot the committee is finding itself in right now, which is there are 19 findings that were created in 1973 that are all fairly extensive. Those are typically referred to as the capability and development findings. There's also the actual plan itself. Neither of those are particularly easy for the public to access or understand, and no one really appreciates how they would actually integrate into Act 250 were you to add them in. We think that this is one of those areas that would really benefit from some of the planning community and other persons coming in and looking at what those findings are, updating and modernizing them so that they meet sort of our current economic development and land use objectives and environmental protection objectives that we have today, and then coming back and how we would then sort of integrate them into the fabric of Act 250, and then present that to the committee for the next session for a more comprehensive sort of planning view in the context of Act 250.
I would respond that that is an option you have, but the Commission on Act 250 did do that. They spent time working with the advisors, and this was one of the direct recommendations that they came up with. You do have the option, because you have been debating it, to further look at it, but that was one of the direct recommendations from the Commission.
Was
To how it's drafted in your bill currently.
Then I think we should go with what we have drafted in the bill currently, if that's what the Act 250 Commission said.
okay, and then just, Evan, one more time. The connection, we were understanding the, I can't find the line right now, but that linked these back to,
Oh, right, so there was a concern that so right now in criteria 9, there exists a sentence that says that these legislative findings, which we've been talking about, are not to be used as additional Act 250 criteria, but on page 56, lines 11 through 13 of the committee bill, version 10.4, that sentence is struck. And so the concern is that people are going to assume that the reason why that sentence is struck is that because this committee now wants all of those legislative findings to become additional Act 250 criteria, and given the way that they're worded and their breadth, they could be very difficult to implement. So we just wanted to throw that out there as food for thought, so that you could give some additional consideration to what you were trying to accomplish in deleting that sentence.
I don't really understand why deleting that sentence would make people think they were criteria. The criteria are pretty clearly laid out as criteria. They just say, like, here's the criteria that we evaluate developments by.
Yeah, I mean, as a lawyer and litigator, it's the inference that I would draw, and I drew it pretty quickly. And I don't proclaim to be the smartest lawyer in the state, so I'm assuming other people are going to at least make this sales pitch, and it invites litigation. They're going to say, you deleted this and you updated those findings. Aren't we supposed to infer 1 + 1 is 2, and we should be able to argue a permit should be denied or conditioned because of those findings? rather than because of whether or not positive findings could or cannot be made under the 10 criteria. Yeah, right.
I totally agree with that. I do agree with that.
Yeah. But a simple thing, I just appreciate this language here, cause I do think we're talking about
When
modernizing
you
Act
say language
250.
here, you got it.
I'm sorry, the language that we have in section 1.
What page?
On page 3, this is what we were talking about. Because I think it's important as we as we are modernizing and evolving, and we're helping to identify what has emerged to become important priorities for the state. Would it make sense to simply not strike that language on page 56, line 11, because for the very reason, Madam Chair, that you had identified, which was that we already have in place criteria that we use for Act 250 evaluations. And by not striking that language, but yet moving this into the purpose, will help provide that clarity, will help illustrate and demonstrate that we're not adding X number of additional criteria to the process.
Okay. I'd like to try that.
I think that's
Move that to the purpose.
That helps, I guess.
Yep. Okay, for the next draft,
Unstrike.
we're gonna have the hybrid too, and move this to the purpose. That's gotta take care of a lot of pages in here. Are you good with that?
Yeah, can you say it one more time, so I'm,
Putting back that language on page 56,
Okay.
line 11.
okay,
Unstrike.
Unstrike.
New word.
Strike.
Now we're cooking with the others. Did we get to page the other day? 15? What page did we leave off?
yep, where the board starts.
Oh, yeah.
So now we got the board.
Yep, page 15.
15.
Right, so that's where the board starts, but it's not, we can skip over that now, I think, cause I'm gonna need to
Boom, we love that.
Yeah.
rearrange a lot of things.
Good, good, good.
On page 40 now.
Well, what about quarries on page 39?
Well, so, actually, so before page 40, I mean, we can go
I'm
wherever
joking.
you want.
I'm joking. Just-
No, we need to get,
I
I mean,
was
we shouldn't
joking.
just flip through, let's make sure there's not something embedded in here that we need to address.
I was just being
Ethical
facetious.
standards. Yeah, ethical.
I mean, some of this language might need to stay in, and isn't there like retirement of a board member? I don't know if that's addressed somewhere else. Or-
Right, no, I need to sort of line up all the things, and I assume a good chunk of it is related to the joint proposal. Personnel is one, so I, in order to understand your hybrid, if you wanna talk about, so hybrid 2, we have the district commissions, what powers are they going to have?
They will, be involved in review of minor applications.
So like on page 18, this draft contains giving them the ability to hire personnel. Is that power still relevant?
To hear a minor, I don't know, but I don't. Evan, does a minor application ever benefit from the hiring of
You mean like outside experts and
Yeah,
stuff?
right.
I think, I mean, that happens very rarely, and I imagine if something happened that would warrant hiring an outside expert, it would get kicked into a major.
Yeah, that's kinda what I was thinking.
Yeah.
So maybe not relevant, nope.
Okay.
It does say the board, however, on line 14. And so
Cause she has to fix.
I think we are gonna have a board in hybrid two.
Yeah, I mean, I guess it's been put out there as an enhanced natural resource board. Do we really need to write enhanced throughout statute? It seems like, no, we don't, okay.
No, because I'll have it at the beginning in the definition section.
And then it can be the board.
Yep.
Yeah.
That's good.
Yeah.
Yep.
Yeah, so I was actually mostly asking about the underlined language regarding the district commission's power to,
But I even mean, like, do we wanna, I mean, like, we want Vermonters all for the next 10 or 20 years calling it the Enhanced Natural Resource Board? I don't think so.
No, I don't think so.
No.
I wouldn't even
Call
just,
it the natural
Well,
just
she would define it up front as the board.
Natural Resource Board.
Natural resource board, it's
Yeah.
just different figuration.
Yeah, that's the Natural
Yeah.
Resource Board. Or maybe the.
Oh, no, that would be,
No, just natural
well, they,
resource
if we
board.
don't change their name, then they don't have to spend money on rebranding everything.
And it's
Get a
gonna
new
sa-
logo.
It's gonna save us so much in the paper in this bill
In this
because
bill.
we strike natural resource board many times currently in this draft.
Okay, anyway, let's just call it the Natural Resource Board. We know what we're talking about.
Okay. Okay. And we're doing judicial nominating process for the board.
Yes.
Okay.
What page?
Next, how about page 23? Another potential confusing issue. Alright, page 23 is another small thing that this is not new language, this is still one of the original recommendations from the Act 250 Commission. So this language that's added in section 6027 regarding the supervisory authority of the board and district commissions comes out of case law. So it's existing precedent. So but putting it in statute does often add clarity. So the board and district commission shall have supervisory authority in environmental matters respecting projects within their jurisdiction and shall apply their independent judgment in determining facts and interpreting law. So that comes from fairly old case law, and it was added for clarity, but also as part of the discussion around permits and preserving the power of the board to evaluate permits and not have them be conclusive. Part of the Act 250 Commission's study involved looking at whether all A&R permits should be dispositive or conclusive, and the board, the Commission on Act 250 wanted to make sure that change didn't happen, and so adding this language, which was existing precedent, sort of clarified that.
Yeah.
How are we choosing the commissioners that will sit with the other three? Are they gonna be chosen by the nominating process as well, or is that gonna be based on the region that's where the project is being planned? How do they get to be on this board?
They're currently governor appointed, so you can discuss that
They're currently
option.
governor appointed, and I think we've talked in this group about saying that should happen in a timely manner, and making that clear, I guess, in statute, because those appointments haven't necessarily been happening in a timely manner.
I think we should give them a number of days and that's it.
Well, I'm just confused then as to how, this, all we have done is really create a five-member board. How will the district commissions themselves, the individuals who represent the districts now, they will play no role?
No, so the district commission, I'm imagining there's still 3 commissioners. 2 of them, most likely based on who's available, will be involved in the review of major projects in their district.
And will vote?
And will vote fully. But the question would be, how do they get chosen? First of all, how do they get appointed to their district commission? Right now it's the governor, and I don't have a big reason to change that. If anyone else does, I'd like to hear. And then, but how they work amongst themselves to decide, or who decides, which of the two join the
Right.
new Natural Resource Board. My guess is they're not really gonna be fighting it out. My guess is it's gonna be like, oh, I'm traveling, I can't, or, you know, who's gonna do this? And rotate. But do we need to expressly say in legislation what we expect? We don't right now. Right now, there's three, in fact, Evan, it's, right now, there's 3 district commissioners up to 4 alternates or something, and, I mean, when I was on a district commission, we had that, and generally the 3 main people it would be like if they weren't available, somebody would rotate in, someone might have to recuse themselves, someone, you know, whatever, but it feels like we just talked amongst ourselves and decided. Is that what's happening now?
Yeah, that's pretty much right. And there's the chair, and then there's 2 members, and then there's 4 alternates. And usually the reason why an alternate would get put on the panel is because of some type of conflict of interest. But there's no prohibition against just assigning some alternates to get them more experience or something. You could do that, and that can happen already.
So we can generally keep that
The same.
but then how we need to decide amongst ourselves who goes to be on the major application reviews.
Yeah, I mean, you could just have the board chair decide that. I mean, right now, the board is given statutory authority over the general, administrative running of the board office and the district commission office, including things like staffing levels. And it works pretty well that way, so.
When you say the board chair of the district commission chair, or the board?
No, so right now, Diane Snelling, chair of the Natural Resources Board, statutorily and then through the delegation of authority from the rest of the board, has sort of general oversight over the administrative HR business type operations of the organization, including staffing. So making decisions about conflicts of interest, whose workload might be so high that we should assign someone else to a particular project.
But for district commissions.
Yeah, so the
chair of the board holds that authority today.
For some of the stuff, so for like if a commission has too much work going on and they want to transfer a case to another commission, board chair decides that. If there's a conflict of interest and a commissioner doesn't want to just recuse themselves automatically, then I think the board chair weighs in on that. But if it's just generally like, we need 3 warm bodies to hear this permit proceeding, the chair of the individual district commission takes the responsibility for figuring that out, and it works pretty well.
And is that delegated authority from the board chair to the chair?
No, I think it just happens that way.
Okay, so the district commission, that's the piece I was trying to get to.
Yeah.
So we can leave that the same.
Yeah, we can leave it the same.
Okay.
So let's say we have a major project in District 7, and you've got 3 commissioners already who are serving, and now we're going to go to this the new model, which will be a 5-member board in which 2 district commissioners will serve on. How will those 2 district commissioners be selected? Will they be selected on the basis of the district that's being involved? Are they going to be?
Yes.
So they're always going to be. That's always going to be changing. Then always going to be rotating depending on where the project is going to be built or where the hearing is going to be heard. So somebody from Essex who's a district commission now, and he wouldn't necessarily be on this board hearing a project down in Bennington County, or would he?
Correct. So the way at least the joint proposal was presented is that the district commissioners would come from the commission or the region that the project was taking place in. So you wouldn't take someone from Bennington and
Right.
take them to Newport for a project.
Mhm.
You'd have people who are basically appointed to that commission. So it may be somebody, so there may be a number of different towns in District 7 who have commissioners who are appointed to that board. They'd all go to Newport to hear the hearing on the project that's taking place in Newport.
And this would be true for majors as well?
Yes, so if it's a major project,
Mhm.
the 3 members who are from Montpelier would drive to Newport and they would hear the project in Newport with the 2 commissioners that are regional.
That, I'm just, okay.
Yes.
Thank you.
Carol?
I just want to back up for a second. I think I'd rather have the board chair, the district commission's chair, decide who the two are that go. rather
That's what we
than-
just decided.
Oh, I'm sorry, I thought you said the coordinator. would
The
decide.
district commission's
All right,
chair. Good, okay, is everyone clear on that?
sorry,
Commission.
I heard coordinator.
District Commission Chair, right?
Okay. Did that answer whatever we were talking about?
Yep.
What were we
Alright, we're on page 23.
We're making it. You
We're
got
on page 23.
23.
We just talked about supervisory authority. We're gonna move on.
Yep.
Okay. So we can skip to page 26.
So bottom of page 25 won't happen anymore. Or, no, it will.
Oh,
It will be
so-
deleted.
Okay.
We will
So
repeal it. And I got myself stuck on underlined repeal.
right.
Sometimes we all lose
Um,
it.
yeah.
Great. That'll stay.
Page 26 is compensation for district commissioners.
I think this one we need to talk about.
Yeah, I think we need to make it higher, personally, and I think since we've got money in it anyway, it's going to go to appropriations, so we might as well put the correct amount in. And I don't know what the correct amount is, but it's not $50.
We have it at 100.
100, we doubled it.
All right, so I think does that seem right? And are we gonna run into trouble because that's $50 more than other people are getting, or no? Other people are getting 100.
I don't know what the per diem for other boards and commissions in the state are.
We get 50 if we go.
Right, we get 50. All right, so I like it. Can I like it? It's not gonna be an issue.
There's
You can like
so
it.
yeah, I think is 100.
Enough, you mean?
Yeah. Is it? I mean, it's
I
certainly
could
it's
go for more than that.
better than nothing.
Better than 50.
You think 150?
No, well, no, I'm not, I know it should be more than 50, I'm not sure what the amount should be.
Maybe it'll be. All right.
I mean, you
Let's.
could-
Why don't we just leave it?
Yeah.
I think, yeah,
Why don't we stay at 100 for now?
I think that's
Yeah.
fair.
Yeah.
And I need to have clarification on what we decided just before that.
Sure.
Is the action to unstrike that?
No.
No.
No. What's the action? To leave it strict?
No change.
No change.
So they
Well-
repealed.
No change is a change.
Right. So I mean, we're going to be striking the references to the environmental court
Yep,
generally.
good,
So
good. Want to make sure that. Thank you.
Like the cor-
So next, section 6030 is the maps. I added language, just a couple of words on line 14. So it now reads, on or before January 1, 2022, the board and secretaries of Commerce and Community Development, Digital Services, Agriculture, Food and Markets, Natural Resources shall complete an update to the capability and development maps created under this chapter in 1971 for use in issuing permits under this chapter. So that's the phrase I added in response to your question the other day about how to get them to be used. Do you want more language than that, or
Sorry, that's on
line 14?
Oh yeah. Issuing permit. So we've and I guess critical resource areas will come out.
Yep.
Oh, hi, no. You already said no. Okay.
Oh, and I can keep reading. I
Yeah,
just
that'd be good.
Maps updated pursuant to this section shall be consistent with the capability and development plan and shall include and identify environmental constraints, existing settlements. I'm going to strike rural and working lands areas and critical resources areas. Facilities and infrastructure and targeted areas, and areas targeted for conservation, public investment, and development. The board and secretary shall complete further updates to these maps not less frequently than every 8 years. The board shall lead and coordinate the completion of updates pursuant to this section.
So the administration doesn't think we're ready to do this. And I guess I need to understand that. It seems like we have so much information available, and the intent of this is to provide guidance, and maybe by having this professional board will already get this, but as to the relevant data that can help make decisions under this title, that's available, and that was a consistency thing. Like, here's maps you can use to help you make decisions under the criteria.
So again, I think part of the concern around this goes back to the concerns around the capabilities and development plan itself, and the fact that we're dealing with a plan that was developed in 1971 and hasn't been updated since then. And so how do you update maps based on a plan that is likely not reflective of the other priorities that the committee is looking at in the context of Act 250? And I think there's a concern just about the challenges of doing some of the mapping without sufficient policy guidance on how to do it within some of this. I don't know if you want to add to that, Evan.
No, I agree. I haven't Meenan again from the NRB. I mean, it's not that we don't see the value in updating the maps. It's just that we wonder whether or not it will really be as effective as it could be if we don't also update the capability and development plan. And because of the age of that plan, I mean, we either have the ones in the legislative findings from 1973 or the interim one, which I just sent to Mark. Either way, it's over 30 years old. So updating it could be a time-consuming exercise. And to get that right, we would want to engage in a stakeholder process. And I was just looking, there are still statutes on the books that dictate the process we would have to follow to change the capability and development plan. It's not necessarily a quick process. So I think that's the concern, is that, why just do the maps? If we're gonna do it, let's really do it. And that's gonna be a difficult, time-consuming task that we should probably put a lot of thought into.
Jim?
So then, we put language in, well, for the simple part, to say on line 15, with the updated capability and development plan, and then we put in the language that says this is how we do it, and we're gonna do it.
Yeah, you could do that. The committee could definitely pass a bill that requires the board to update the plan and the maps by a date certain. You could definitely do that if you wanted to, and we would do our very, very best to make it happen.
Yeah.
So I guess the only thing I would add to that is you should probably have the board provide to the legislature a draft plan, because it requires legislative approval.
Yeah, there's a whole process. It requires gubernatorial and legislative approval. It also requires some public hearings.
Can we change that language?
Of course we
Yeah,
can.
that's-
Of course
Next
we
building
can.
committee.
It's subchapter 3 of
Act 250.
Yeah.
Okay.
But yeah, there's several provisions.
So we could say shall be consistent with the updated capability and development plans as prescribed by the statutes that you just were looking at. Statutes and procedures, and then and make this section not apply until that work has been done.
But make it apply by a certain date, so they'll hurry.
Well, by a date certain. By a date certain. And of course, since it's gubernatorial approval, who knows?
well, you know what, it's either that or the maps are gonna go the way they are and that's what's gonna happen.
The legislature created the board, and it can tell the board what to do, and we'll do our very best to follow those directions, you know?
So remind us how the joint proposal addressed this. There's a study in there.
Sure, the joint proposal addressed it by taking a comprehensive look at both the existing capabilities in development plan and the associated findings in the 1973 Act, and say, you know, do we need to update them? If so, what are the recommendations on updating them? How should we incorporate them into Act 250? So to give guidance to both the board, frankly, give recommendations to the legislature to give guidance back to us on how to actually implement them, and basically come up within, I think it's about a 1.5 year period, with a suite of recommendations. I think I will just say from the people who worked in the joint proposal, there's just a lot of questions about how to integrate the capabilities of development plan into Act 250 that we think would benefit substantially from additional work by the planning community, you know, the local planning, regional planning community, and having them involved in that process.
And certainly some of those questions could be answered during the process of updating the plan itself, but until we at least delve into those questions, you know, any deadline that we come up with for this work is going to be somewhat arbitrary. I mean, we don't even really know the universe of the work that we would be undertaking at this point because of the age of the documents that we're dealing with. So I think if we spent some time looking at this issue, we could come up with a realistic list of objectives and time frame for completing those objectives.
There's a member of the planning community who's been really with us a lot, and so would you like to comment on this? Do you
Well, just the
Can you
planning
just for the
community,
record?
I'm sorry, Peg, Elmer, Hough, and I don't know if I can say I'm speaking for Vermont planners because that's a very vetted process, but the planning community and what our recommendations were coming from the conference and to the Act 250 Commission is that we've been missing the state level plan. This should be it. And so there should be a connection to the regional plans and the local plans. They should all fit, they should all be aiming towards the same objectives. So there needs a reference to Title 24, BSA, I don't know if it's the
4302?
Yeah. So that they all sort of start melding together. And I guess I'm glad to hear there's a public process. It seems like the development of the plan by the Natural Resources Board should be a very open process, so that you've got the regional planning commissions and some entity of the Vermont Planners Association, the planning and the various state agencies with planners, just have them working together on that state level capability and development plan.
Okay, so I'm hearing that we all share this as a goal and that it needs more work. And so getting us to the place where the legislature is reviewing a plan at some time relatively soon. I know that we're going to have to look at the dates of this, and having it be something that the Natural Resources Board leads us on makes sense. It's what you put in the joint proposal. Okay, so what other guidance can we add? What else needs to be said right now to help Ellen draft us something that does that? Jim?
So, I guess I'd like to see that language, and I'm fumbling here. Right now I've got January 14 agency proposal, but I think I need the joint proposal, is that correct?
Well, I think if it's the agency proposal, the
Yeah.
one that A&R put in?
Yes.
Yeah. Yep, that's it.
But I'm thinking yeah, the topic is bigger than the 11 of us this afternoon, and the whole idea of a comprehensive look appeals to me.
You're talking about the language for the study committee?
Yes.
Yeah, in section
Yeah, so
11.
it's on your side by side.
Section
too.
11 of the January 14 1.1.
And Carrie, did you have something you wanted to add?
Oh, I just wanted to support what we're talking about. I think we're at a crossroads here in Vermont with economic issues, with our rural landscape, our working landscape, We want to see a continuation of our agrarian economy and our working landscape-based economy. And I think that this can only help all that. It provides us maps to help us preserve and protect our agricultural uses of our landscape. So I'm really thrilled about making sure that we take the time and do it right with the planning input that I hear. We could certainly take advantage of some of that expertise and the public engagement. So I just wanted to mention that this is an important conversation because there's going to be some huge value in helping us deal with some real major issues in my mind about how the state of Vermont can support our rural economy.
Carol, all right, so I'm hearing that we'd like to insert the joint proposals with consideration of what the Vermont Planners Association recommended, if it, about what Peg just said.
So do you want me to take out 60-30?
If that's what it takes, yes. But I want to make sure, I don't know where it belongs, what we just said. We would like the study, and I guess it's in the end in session law. That's the difference. So wherever you know that it fits.
I'm worried
Well,
that
I
if
guess
we take it out, that we won't be saying this has to be done.
Well, so you have an option. If you can have the study committee, you could also, so on line 10, it says January 1, 2022. You could set that out pretty far, or we could take out this section and have the study committee look at it and then come back with recommended language for this section.
I like that idea. I like the idea of our putting it there with a date.
Is that what you just said?
Yeah.
There were two ideas there.
Oh.
Yeah.
Well, I want to put it there I want a date in here.
Can
and
you
I want
say your two ideas again?
Sure. So right here on page 26, we could change January 1, 2022 to say 2032. 2030.
What? A year?
Okay. Well,
A year
Not
2030?
that far.
yeah.
Can't take them 10 years.
Well, all right. So that's what I'm saying. Though you
Okay.
could pick a far out date because the board is going to take a year or two to get set up in itself, and then plus time to do the research. Or I can take out this whole section and have a study committee look at it and come back with the language for this section.
No.
Can't we?
Say we put like 2025 or 2024 or 2026 or something, but I think
Sure,
we
we
should
could-
make the decision now while who knows what's going to happen? Who knows whether we'll ever be able to touch this law again?
I agree.
Yeah.
Right.
We're on
We
a
should
roll
set a date
here.
now.
Jim.
I'm thinking first of all, a question for Matt. So the January 14 version 1.1 from the agency, section 11, is that verbatim with the joint proposal?
Yes, it is.
Okay, so given that, I think I prefer substituting the sanitized version, taking out natural resources board, just the board, wherever that appears.
Jim, hold on one second. Can you say that page number again so I can follow with you?
It's version 1.1 of
Yep.
the January, its page number is 84.
Thank you.
Yeah, line 4. And it does everything we want it to do, I think, maybe and more than we have in our language.
2
and-
years earlier.
Yeah. And they've already figured the date, so we don't have to sit here with an auction trying to figure out a date.
Maybe. I think our legislative council maybe needs to review them. Just have one more set of eyes, but yeah. Okay.
said it's the same as the joint proposal.
Yes, Trevor.
I just had a question about this on line 8, page 84. Seems to me the first option in looking at this is whether this should be incorporated into Act 250. So I'm not so sure I'm happy with the ability to do that, okay? It should, somehow it needs to happen. How it happens, that should be the part of the process, okay?
And you would keep the language and what changes should be
Exactly.
made, because there's gonna be some changes that likely need to be made, but,
They shouldn't have the option, but they're
Okay.
gonna do it.
so,
I defer to you for that.
okay.
How, we can, yeah, whether can be how.
These all start with whether.
Yep.
Yeah.
Doing-
Right.
Gonna be a lot of snow, that's gonna be the weather.
Yeah, that's what I was just, glad you made that joke, I was about to do. All right,
So you're saying perhaps substitute how instead of whether for all of these?
Yes.
yeah, try them on.
Yeah.
Right now, we're pretty solidly trying things on, just for the try-on record.
How to Ka-ching.
Okay, so is that clear enough for you, Ellen, to move forward? Thank you.
So, I think the next issue is the ethical standards. So, this draft 10.4 of your committee bill added the so-called Chinese wall provision regarding ex parte communications. I think that probably needs to be taken out if the district commissions are going to be contributing members to the board's process.
Jim?
Yes, except for the fact that if we do have an attorney from the board assisting the district commissions, and then there's an appeal, is that the same thing as the Chinese wall, so that person would have to recuse themselves in the appeal? That's a little different than the Chinese wall.
So, assisting them in making a determination
Yeah.
on what?
On the permit application before them, which ends up getting appealed to the board, and that attorney is a member of the board, but then that attorney would need to recuse herself or himself in that deliberation, because she or he had helped craft that with the district commission. That's not quite the Chinese wall thing, but
So we're talking about primarily jurisdictional opinions and minor applications?
major, yeah, sure.
Not majors.
Yes, major. So if, wait,
I think,
no,
You're-
that, yes, what you first said, really,
so
because,
jurisdictional opinions.
yeah, and
And minors.
Yeah, because that's where they'd be down down, if you will, or into
Yeah.
the district commissions and helping. Yeah. That's not ex parte, it's, that's.
I don't know the answer to that.
That's
I
a
have,
different issue.
Yeah.
Trevor, or Matt.
So I just wanted to say, so when we approach, so first of all, let me say that generally speaking, I think that the provisions that are in this draft are appropriate. It basically prevents people who have worked so it prevents those ex parte communications, which is my talking to a permit applicant without other people participating in the process. It prevents that type of behavior. It also prevents if I have some sort of fiscal interest in the permit that's being considered, I can't participate. If I were to make a recommendation, I think it should probably apply to any employee or member of the board, so that it applies broadly in its scope to both members and employees, especially if employees are going to be serving as hearing officers in the context of this. So.
I agree, because your draft was contemplating not having the board. This, yeah, I think I agree with that.
Jing?
Did you want to say something, Evan?
Well, I was just going to point out Evan Meenan again from the NRB. This is a pretty detailed section regarding ex parte communications, the subsection 4. And just as a reminder for committee members, even though there's no specific provision in Act 250 regarding ex parte communications, there is a prohibition on ex parte communications currently right now in all Act 250 proceedings, because we're obligated to follow the Administrative Procedures Act, and Section 813 of the APA prohibits ex parte communications. So as you're considering this section, it might be useful to look at that one and figure out, is there really something about that that you don't like, that you're trying to clarify or
I think what we're trying to get at is a rule that was promulgated by the board that has allowed conversations. I think that's what we're trying to get at here. Is that right?
Yeah, and this came from the testimony from Jim Dumond about there was a change in board rule that was allowing ex parte communications.
I'm not familiar with how that would even be possible, because the board can enact rules that trump state statute.
You did send us it was a memo back to the legislature saying we did this. And it's probably under Jim Dumont on our webpage.
Take a look and see if I can find.
However, what we want to do is put good language in for the new structure, and all of that was for history, so let's be forward thinking and make sure we're clear. And I think Matt's in here, you support generally the intent of this.
Certainly the intent. I mean, I generally agree with Evan that the APA prohibits the ex parte communications. I think this is clear and broad in its scope. I don't think it's inconsistent with when we have a contested proceeding, how we approach them. There's some relaxation in there in a certain instance. I mean, I think the other thing that's just important to note that the ex parte communication doesn't apply pre-filing. So to the extent that you haven't filed an application yet, an applicant can reach out to the board and basically ask them questions about Act 250, and I think we want that, right? Because we want to have pre-application communication so that people understand what requirements exist under Act 250 and how they need to file their applications.
So I haven't found the memo that Jim cited, but I'm looking at his PowerPoint slide, and the very last bullet point is that the bill should explicitly state that the prohibition from the Administrative Procedures Act should apply to Act 250 proceeding.
He's saying we should reiterate that.
Yeah, I mean, that already, but the point is, like, the two provisions, the proposed one and the existing one, the APA, they are different. And so I would just give some thought to, are those differences meaningful? Is there something that's really wrong that people are trying to fix?
I think we just want to be clear about ex parte communication. And so to the extent that, I guess this, we should decide, do we wanna reiterate the APA year or, yeah.
My preference is to reiterate because I hate to just, even though these are important and what we're trying to hone in on, I think it's fully realized in the Administrative Procedures Act.
Which I suppose could be updated and that might, we might want that to apply.
Yeah.
So,
I've worked under that, it's pretty darn restrictive. As it should be, but, I always want to make sure that we're consistent across, you know, and it applies to all ex parte where it applies in state law, so I think it's, good to reiterate it here, so we don't lose any, or get it misinterpreted.
do we have a direction to head? Are we just gonna say what Jim Dumont recommended? Okay.
That's my recommendation.
Are we losing anything, Ellen? Sorry, I'm being a little distracted by other communication. I'm having ex parte communication. They're not about this, actually, as I say that. Yeah, that was a bad joke. It's not, no one's trying to lobby me on this. It's not related. Dinner plans.
I can either take out all this language and have a cross-reference to 3 VSA Chapter 25.
That's what I
Yeah.
prefer.
Yeah, and I just wanted, like, will we be missing anything substantive by doing that?
I don't know off the top of my head.
Okay, so I guess I would like to do that, and then I'd like to hear after you do it what you think. Thanks. How are folks doing on break? I'd like to keep going at least till 5 today. It's 4:15. We last had a break at 2:30.
Whoa, I've had so much fun, I never realized.
That's a good sign. It's really good for your heart to get up and walk around.
Yep.
Let's
10
take,
minutes, you said?
can we take 5? 4:15.
That means
Obviously, I keep them up.
We will reconvene. Our meeting. Is everyone with us?
I'm here. So, I want to raise something that Evan just pointed out, but we should talk about anyways. So, as I draft hybrid number 2, I'm going to need to disentangle a bunch of things that were part of your original verb. And one of them is on line 9 of the page that we're currently on, which is 28. So, line 9 is an ethical provision related to permits, and this was part of when your verb was hearing A&R permits, A&R permit appeals. So, I don't think this necessarily is something you want to keep now that that your board is not going to be hearing A&R permit appeals.
Right, do that.
Right. But we can talk about it.
No, we can't.
No.
No, we
move
can't.
on.
Okay. So,
It's time to make sure I understand it.
sure. So disqualifying people who directly or indirectly receive income from holding A&R permits. And Chapter 47, that reference to
You can get paid to hold A&R permit.
well, if your business has an A&R permit.
Okay.
Yeah. And Chapter 47 is the water quality chapter in Title 10, so that's where a lot of the
Okay.
water
So
permits are.
it's not relevant now because we're changing the structure.
Right, I think there's concern that there would probably, yeah, it would be difficult potentially, yeah.
So those people, are then under the jurisdiction, as they currently are, of the court, the E-court.
Yes.
Yeah.
Yep. I'm going to have to amend the E-court section to just, in your bill at least, to put it back to where it was and mostly just strike the Act 250 permits from it.
Yep. All right.
Okay, so that raises another thing, in that this draft 10.4 contained a bunch of language suggested by Jim Dumont in his proposal to strengthen the district commissions under this section 6031 about disqualifying people from disqualifying district commissioners based on interest, and so basically it took away the board being able to disqualify a district commissioner. So I'm going to remove that language because it sort of is in conflict with what you're doing now with your new board structure.
Why?
Uh,
We'll still have district commissioners.
So it allows the board to disqualify district commissioners, which is
Too broad.
Yes, I thought our whole goal was to just reference the 3 VSA section 809.
Yep, I'm
when
not-
we're dealing with tax party, is that what you are?
I'm not talking about that. No, I'm talking about like on page 30. So, on receipt of a motion to disqualify a district commissioner, who is the subject of the motion shall disqualify him or herself, or shall refer the motion to the chair of the board, and that was changed to having a consultation with the council. So, I was going to undo that and leave it as the status quo language, but are you interested in having a district commissioner consult with council before being disqualified, or?
Well, this brings up, what happens if one of these 3 professional board members has a conflict of interest and can't
So,
participate?
that is addressed,
Okay.
back on that's the first part, that's 12 VSA 61. So that's built in, on page 27, so under the ethical standards, 12 VSA 61 is disqualification for interest, so if you have a conflict of interest.
But who fills in for them? At the enhanced natural resource board level?
So, with a district commissioner, you're using 2 out of 3.
And we have alternates.
And we have
But there's no alternates for the other board. What happens at the PUC?
They play a man down, I think.
Ooh, and then we're 2 on 2.
Pity.
Goodbye, girl.
It is what it is.
Yeah, that's a good reason to have us on.
It is? What were you guys saying?
Evan Meenan again from the NRB. So I don't know how the PUC does it, but what I was saying is, what I was asking Matt was whether or not the joint proposal specifically addresses this, but if not, the options would be, you could appoint 3 full-time professional board members plus alternates to have a backup, or you could just go with those 3, and then because there's gonna be regional representatives from all over, you could just effectively use them as your alternates and pull them in to get a quorum
That makes sense.
to make a decision. Either one of those options, we could have a person power pool to draw from.
Okay. Yeah. So, which one? That's 2 options, we've gotta choose. I mean, I sort of like the second one.
I do too.
Easier, okay. Does that make sense, Ellen? And where I put it, it's up to you.
Yeah.
Wherever it belongs.
Yeah.
Did you have something?
No, it's fine. I was gonna ask another question, which is, if you have a sense that there's some enormous project that's gonna be very difficult, you would have the discretion to put on a full contingent plus alternate so that you could see it through.
I'm not
Like,
sure.
let's just say there's something that's a major, and you can see this is gonna be big, you know, it's gonna go on for a while. You could assign alternates just in case somebody moves, gets sick.
Like
The 13th juror?
Yeah.
Yeah,
Yeah, I was thinking backup jurors as well. I
like
said the
a
same
backup,
thing.
that's what, yeah.
Well, you know, if
There's nothing that prevents you from doing that with this, or do we need to say?
I'm trying to think how it would play out right now. So if it's a 5-member board, a quorum would be what, 3, Matt, right?
Mhm.
So you could still lose 2 and still have a quorum to issue a decision.
Okay.
And if someone is still well and breathing, but their term has expired, there already is a provision in existing law that allows them to see the cases out, like through to fruition.
Okay,
So I think
You're okay,
that that'd be
I'm
a,
okay.
yeah.
I think it's.
this is your chance to do something. Speak, forever hold your peace. Okay.
Okay.
Does that mean we're okay there, but now back to, line 3, on receipt of a motion, a district commissioner who is subject, that's page 30, are we back there now?
Sure, would you like to, what would you like to do?
Well, I just wanna make sure we're through, we came to a decision on the board, in case that the board might have somebody recuse themselves or be disqualified.
So I will draft language having the chair of the board assign a district commissioner
Okay,
to fill in.
okay, good, I didn't know that I heard that was gonna happen. So then we're now back on line 3, page 30. And the question was whether we were gonna,
Unstrike so that it goes back to the status quo language,
right,
which would allow chair of the board to disqualify district commissioners or district commissioners to disqualify themselves. The intent of that change was to take power away from the board, and so I think it should probably be unstruck, but it's up to you.
so
Yeah.
I'll respond to that. I think I think unstrike that and get rid of the issue a decision after consultation.
Are we talking about the one at the bottom of the page?
Page,
Oh,
page
at the top.
30, line 3.
I mean, it's all of it is related.
Yeah.
Yeah.
May I ask one question? Yeah. What happens if you have a district commissioner who there's an obvious conflict and they decide not to recuse themselves?
So the board, if I unstrike this language, the board can remove them.
Great, because that's important. I've seen that play out on the local setting, and it's not good. Found it painful.
Alright, so I'm gonna unstrike it and have it go back to the existing status quo language. Okay. Section 6081, permits. So, first, so we're in the exemption section of the permits. We're on page 32. The first change, and this may be my mistake, but I left in that pre-existing pits and quarries have to submit extraction data. Did you want to keep that? So you have to submit extraction data so that the board can establish a baseline against which substantial changes may be determined.
Yeah, we talked about taking it out, but it is a good idea. So, I'm not sure if folks want to reconsider that decision now. We talked, yeah, Jim.
So, the overall, I think, the overall tension is whether Act 250 ought to be regulating the slate quarries.
No, this is all quarries.
This is just the pre-existing pits and quarries. This isn't specific to slate. And so this is about the difficulty in determining what a substantial change is because they're pre-existing and they don't have Act 250 permits, it's difficult to know for someone to challenge whether or not there's been a substantial change.
Mm-hmm. And I think that we ought to keep that language. But continuing with the thought about slate quarries, this can still be applied to slate quarries without our going the full 9 yards, if you will, of Act 250 total governance of them.
Would it apply to slate quarries, Ellen?
Throughout the rest of this section, we make reference to registered slate quarries, and those are what would be considered pre-existing quarries. So there's some slight ambiguity there if we need to also mention registered slate quarry owners.
Well, and also if you go from zero, it's something held in reserve, to something, would that be a substantial change? But it's held in reserve, so the held in reserves are exempt, so that may, if our intention is, we have to be clear here. Who's keeping track? Carrie?
I pulled up our notes and it was brought to our attention that we didn't have any witnesses or testimony on this issue, so we'll need to remove it because of that.
Well, I said that, and I think we may have taken testimony last year on this issue. But, yeah. I think that's why it got in there. Anyway, what's the pleasure of the group? Evan, how would this be implemented?
I was worried you were going to ask me that. I should have left at 4:30. I don't know, because I was thinking about slate quarries and how this would impact registered but exempt slate quarries. And I know that I testified about that last year, and I think there's some PowerPoint slides and stuff. I'd have to go, honestly, I'd have to go back and look at those again. The slate quarry exemption is complex, as I think I tried to explain. So I would need to go back and look at that and see whether or not it's even useful to have this data point for registered slate quarries. For other types of quarries, yeah, it would be helpful to have. I don't know how frequently we'd tap into the data because quarries do tend to expand and fall within jurisdiction at some point. But the data would be.
Is it needed? You're saying it's already happening.
Well, a lot of core, there are a lot of sand pits and gravel quarries that do have Act 250 jurisdiction on them because they either go deeper or bigger and they expand their operations, and the substantial change has already happened. Are there quarries out there that are operating that have not triggered substantial change jurisdiction? I think it's definitely possible.
But a lot of them are in there.
I feel like I frequently see pits and quarries with Act 250 permits, but I'm sure there's some that don't have them yet.
Okay.
But I'd be happy to revisit the slate quarry exemption, do a little homework and come back if you wanted me to.
I don't, so let's keep that, thank you for that offer. Let's hold that and just get through this one. Do we want this requirement in? We had asked for it to be out previously, let's take it out. Okay.
Roger that.
Yeah.
Goodbye.
You know, leave it in,
Take it out.
take it out.
Take the whole quarry thing out.
No, that's not the quarry thing. I think she's just talking about, what we have here.
10 through 12.
On lines 10 through 12, page 32.
Yeah, but I like that we. You don't think we should make any change?
Well, I think make your case, it's just we're talking about it.
I know, I was listening, but I was thinking, I think we should.
What? I can't hear you.
I was listening, and I think it's a good idea to add this underlined section.
Lee.
Just a quick thought, when it indicates submit extraction data, I don't know how you would even do that. How could you tell if we're accurate or not? I think it would be quite involved, but it matters not whether it's there or not.
I mean, sometimes you can see aerial photos and determine substantial. You can, you get aerial photos with date certain and can see pits or quarries at a certain size.
Sure.
And, I mean, I have seen that over time and where, some pits and quarries have, certainly anyone would be able to see that since it's doubled in size or tripled in size, has seen a substantial change. And so I think on some quarries, yeah, you can determine it without necessarily even getting extraction data. You could just even determine
You can
from
determine a change.
aerial photography. And I think there's been a history, and maybe Evan could relate, there's been a history of district commissions really wrestling with this because of not really fully understanding what and how to determine substantial change. And so I empathize with what they've been wrestling with. So if we feel we have taken testimony, then it's worthy to be thinking about it, because I think that this is something that it's obviously been something that people have been struggling with at the district commission level, and there are implications to that. Sometimes if they're adjacent to streams and rivers of valse, it can actually cause substantial flood damage downstream. So I recognize why it is we would want to be thinking about that in the context of Act 250.
Again, I just think it's hard to determine, they can submit data, extraction data, but how does one find out whether it's accurate or not? Are they giving you good information, bad information? So if there's not something there that allows us to determine it, what's the point in having it there, I guess?
It's the kind of thing that would go to rulemaking.
Evan, how does it happen now? That a substantial change, I know you covered this, but I think we need to cover it again. Substantial change is calculated.
Yeah, I mean, there's a definition of it already that exists in statute and rule. It really is it's almost identical to material change jurisdiction. It's any cognizable change, which is really just physical change, that may present a significant impact under one or more Act 250 criteria, or, yeah, that's it, for substantial change. And Representative Dolan was right. I mean, I don't see commissions dealing with this issue so much, but that's mostly, I mean, the lawyers aren't involved in every commission case. What I see is in the enforcement context, when we get like a complaint from someone, a neighbor, and they say, hey, they just opened up a new section of this pit or something like that. And then Representative Dolan is right. We go do a site visit, we bust out all the old aerial photographs. Google Earth has some great tools. Actually, A&R just put a bunch of old aerial photographs on the internet, which are very helpful. And that's the kind of thing that we do. And we're usually able to figure out one way or another. There could be some issues with trying to validate any data that someone presents pursuant to this language. I'm not quite sure how we would do that, other than asking for additional information or the raw data, the underlying figures that they produced, and if there isn't sufficient documentation, we might call their report into question, but there could be some difficulties associated with that. And so that's where I see it most frequently addressed, is the enforcement context, and that's how we handle it.
May I ask a follow-up? So would having, I mean, this obviously is setting a baseline, a 2020 baseline, so we're not going retro.
Right.
Active unless you think otherwise through an enforcement case, but moving forward, wouldn't it help to try to establish at least a milestone or benchmark of where we are today?
That's interesting, because when I read this, I assumed that what the committee, and maybe wrongfully assumed, that what the committee was trying to do, because substantial change jurisdiction applies to pre-existing
Yeah.
quarries, means one's operating back before Act 250 in like 1970. So I thought that this was asking quarries to submit extraction data from back then, but maybe that's not what you were trying to accomplish.
Well, when may I?
Yeah. No?
I mean, what, the way you interpret it is probably what we're trying to get at.
I don't know.
Because,
It could have been a wrongful assumption on my part. It really could have been.
but when you define what a substantial change is, you would look at where you would fall under Act 250 jurisdiction
Right, because we're trying
and
to.
see if they're compliant with their permit at
Well-
that time.
Well, substantial change would be for an operation that didn't need a permit because they existed before Act 250. And you're trying to decide, has there been a change since the enactment of Act 250 that would trigger a permit? So that's why I assumed that was the data this was calling for, but maybe the committee wants us to have data for extraction operations as of 2020.
No, well,
Yeah.
I mean, I guess I'm trying to figure out if there's a problem this will solve, that the board has.
I'm not sure that it would.
Okay.
Alright.
Stick with
Then
removing
that's
it
fine.
and move on.
Fine.
It's gone then.
Yeah.
Solve the problem,
Page 33. So we're now in the slate quarry exemption, and so you added language on line 15. The registrant must provide notice of the slate quarry's registration to adjacent landowners.
And that would just be a one-time notification?
Yes.
Once they're registered, they're always registered, is that,
Yeah.
makes sense?
Yeah. It's not like it has to go on their title, or there's no way of the next person buying the house knowing. So I'm not sure. Yeah, I'm just trying to figure out what that does.
You bring up an interesting point, if the adjacent property changes hands, how would those people know? So how do we make the quarry owner aware that this guy just sold his house, so that he has to report it to him again? How do we make that, make that connection so that they will know to do that? There must be some mechanism. If they're going to have to do it to each landowner.
And also, I mean, this, we've taken testimony that this number 4 has happened in varying degrees. It hasn't, that they are supposed to, you know, put it on their title. Their slate quarry.
We're hoping that the town would have maps to show where those quarries are located or in reserve, so that if you were buying land in that vicinity, you would know.
Well, we're adding them to the A&R Atlas.
You're right, and, but we also, I remember there was a great discussion in terms of whose responsibility it was to let the potential real estate buyer or someone buying a home to know that that was, you know.
So the attorney doing the title search work, if it would be his responsibility to make the next buyer aware that.
There are maps.
If
Yeah.
you're doing that,
Maintain a map.
Yeah.
because some
And-
owners plead ignorance that they didn't know, and that's what's the mechanism to make.
The problem is if you're doing a title search, okay, you've already got a contract to buy that's a little too late, you know, at the title search stage.
Yeah.
And also, is it going on the registered's title? It's going on the slate quarry owner's title.
That's, so currently,
Right.
yeah, it's in the land records on the slate quarry property.
So when you do a title search, you don't necessarily do a title search on the adjacent properties, so that's not really that helpful.
That doesn't make them
Yeah.
aware.
How could you, what would you recommend then?
Yeah, how'd you know?
To do what?
So that when someone's doing a title search and they're buying in that area, that somehow something is alerting them to the fact that on their borders or in their area, there are quarries, and that those quarries, even if they're not being used today, may be used in the future, you know, parts of them.
We do have registered slate quarries added to the Agency of Natural Resources Atlas on the next page, number 6.
Alright.
They already did that too, didn't they? Or did they?
Well, it's
not
partly
live?
Talked
done.
about
We
it.
have money in the budget, and this was one
Oh,
of
that's
your
right.
questions for you, Evan,
Yeah.
and Matt, actually, because the map, the Appropriations Committee wants to make sure that the language they've put in the appropriation, in the budget, matches up with the right people who are gonna finish the mapping and that it gets done. And so, who is that? So it was,
So we're doing that. So it's gonna come out, so I think if you put it the Agency of Natural Resources for slate quarry mapping, the work will we'll
Finished.
make sure that it gets completed. I mean, it's basically gonna get transferred to ADS to do the work, yes.
okay. So, that's what it's okay,
That's
so
what it says.
we need to let them know that. I don't think that's our bill, that's the budget. This just says we want it done, and then the budget will provide the money to A&R. Okay. All right,
So if we answered the question,
we have.
No.
Oh, no, the previous one.
I mean, I've sold properties in the past, and I have had a covenant put in the deed, so even if the next buyer was aware of what was going on, I've done it in that manner.
Like for the next door.
Yeah, so it always ran with the deed of
That's
the
interesting.
person buying the piece of land. It
And
always
then
ran
the-
with the deed, what I wanted, I wanted
It's very
to do
interesting.
certain things that butted my
And you
land.
have to go back and
So that's,
amend every deed though, somehow.
so there's gotta be some mechanism so that so that the quarry owner doesn't have to make himself aware that there's going to be a new owner to this land, and each time let him know. There has to be some mechanism where it's, cause how is this guy doesn't necessarily know that this guy's buying or selling his house.
Right.
So he doesn't know to run next door and say, hey, this is a registered quarry next door. There has to be some automatic mechanism so that it just happens. Otherwise, It's not gonna happen.
Otherwise, you're relying on people to know everyone else's business.
There has to be something somewhere recorded that the attorney, that these people, or the real estate person that these buyers are
Right.
dealing with know that this is happening next door.
But
This,
how reasonable is it for us to require them to put that on a deed?
Right.
It doesn't,
I don't know.
then it,
I don't know if we can even do that.
then it does no good to have this sentence because there's no way to have it happen.
Right. Right,
Agree.
okay,
So,
but we have the mapping.
yes, yeah, mapping good,
Okay.
that's good.
We also have existing language that says the slate quarries, you know, are listed in the town records. And a person, a wide-awake person would be prowling through those, as I think a title attorney would be.
But again, it's too late at that point. They've already got a contract just before the closing. The attorney goes and does a title search for them, but
Before the closing was
Yeah.
Yeah,
the
it's not
operative.
too
he's already
It's
put
not
it
just
in.
too
his-
late.
That shouldn't be too late.
It depends.
Depends on the
Well,
contract,
it's
but-
clear title, it still might be clear title, and
Right. You could,
so they.
someone could sue to perform it.
yeah.
That could turn into a messy situation real
Right.
quick.
All right,
could-
page 33.
Title insurance people could help
Just
us
gonna
with this.
Scratch that line then for now.
Maybe we could have a study on this.
There's not a way around that.
So we're taking that out.
We're taking that out.
Yep.
Unless you can think of something.
Page 34, registered slate quarries shall be added to the agency natural resource atlas. So next, O and P deal with the exemption for designated downtowns and neighborhood development areas.
Does it make sense to say atlas or any subsequent tool? Because there's always been talk about periodically about updating the atlas. Or if it ever changes name, I don't know, just a minor comment.
All right, do you guys have the juice to take on downtown exemptions right now, or you wanna do it at 8:30 tomorrow morning?
Let's do that.
I have to go.
Yeah.
Okay. We will adjourn for the day.
Get juiced out.